Welcome back to Savannah Car and Truck Accent Law with Andy Conn. I'm Brooke Steele, sitting down with Andy Conn of Conn Law Firm in Savannah, Georgia. Today is episode 9, and we are answering a question a lot of property owners in coastal Georgia are afraid to ask out loud. What happens when someone else's pollution reaches your land and destroys its value? We are walking through what a land devaluation toxic tort actually is, how contamination travels onto your property through groundwater, soil, and vapor, the legal theories that name the claim, how you prove the pollution came from that neighbor, how the lost value is measured, who can be held responsible, how the Environmental Protection Agency and the Georgia Environmental Protection Division fit in, and how long you have to act under Georgia law. Lots to cover today. Welcome, Andy.
Hey, Brooke, thanks for having me again. Excited to talk about toxic contaminants. And this is one that might not excite everyone out there, but it's an overlooked area of cases that, due to some of the complexities of the cases and not having lawyers who in every single locale are used to handling these types of cases, oftentimes they just get overlooked. But as we'll talk about a little bit, they're extremely valuable cases. And when we talk about land is so unique. Actually, the law even says how unique land is. And so there are some significant damages that you could be entitled to if your property has been contaminated by someone else.
Absolutely. I think with a lot of these types of cases that we've talked about, they're overlooked, and until it happens to you, you don't really think about it. But that's exactly why these conversations are important. So, a property owner just learned the land they have paid taxes on for years is contaminated by a neighbor and has no idea where to even start. When someone else's pollution reaches your property, what kind of legal claim do you actually have?
Yeah, great question. I'll just start. Usually, the way you find out about these things, unfortunately, isn't from the polluter themselves. Sometimes that happens. Usually, you're getting a letter in the mail, though, from either the EPA. We've all heard of the national EPA, or here in Georgia, they have a local division of that called the EPD, Environmental Protection Division of the state of Georgia, who might send you a letter that says you're part of a contamination of your property that you weren't even aware of from a neighbor or someone down the street in some instances. And so, really, what these cases are when some sort of historical contamination, whether it's due to some industrial type of plant, or maybe there's even something as simple as gas tanks being buried underground, leaches out and gets either into the groundwater, gets into your soil, sometimes, unfortunately, even gets into the atmosphere, the air that sort of surrounds or is within your property. And so that's what we're talking about today when we talk about a land toxic tort type of case.
Is this something that Conn Law Firm has touched on or worked on before?
We've touched on and worked on several of these cases over time, some that we can talk about the results, some that are confidential that we can't. One major one that we resolved about 2 years ago was one down in Glenn County, Georgia. We actually filed the case in Gwinnett County, which we were able to resolve for $7.25 million. It was a case that when we got it, there was another law firm who had actually worked on it for 5 years before we actually got on the case. At the time we got the case, it was dead in the water and they hadn't been offering any money for it. And even the plaintiff's own expert had valued the property, I think, way too low and didn't consider many of the things we'll talk about later. We were able to take that case over, right the ship, and settle the case for $7.25 million.
Awesome. I appreciate you sharing that piece there. Let's talk about this. Someone keeps seeing national ads for mass tort cases and cannot tell whether their contaminated property problem is the same kind of case. What exactly is land devaluation toxic tort, and how is it different from the lawsuits people see on TV?
That's a great question. What we're talking about today is different than what you typically are going to see in TV ads. So you might hear, have you been exposed to mesothelioma? Or did you ever live at Camp Lejeune? We've all heard these TV ads. What they're advertising for are personal injury claims, meaning you personally have been exposed to some known contaminant that causes you cancer or causes longer breathing issues or other medical issues. That's not what we're talking about when we talk about diminution in value type of toxic case. What we're talking about are when contaminants migrate typically to your property and cause the value of your land, again, that very unique land, all land is unique, to be worth less or to require some sort of very expensive remediation that oftentimes the government forces you as the property owner to clean up, even though you weren't the one who caused it. So it's really important to hold those accountable who actually caused the contamination so you can even afford to do the cleanup that's necessary.
Okay, that definitely makes sense and can see the difference in those two types of cases now. A homeowner can't understand how a factory a half a mile away could possibly have anything to do with what's in their backyard. How does pollution from an industrial neighbor actually travel onto your land?
Yeah, and there are several different ways that happens. I'll tell you that sort of the most common we see in these cases is an industrial user is using some sort of contaminant, known contaminant, that they have an obligation to contain either on their property or to get off property somewhere secure that doesn't migrate to others' properties. What often happens is sometimes due to negligence, sometimes not even due to negligence, though, sometimes just due to the length of time that they're handling these dangerous chemicals, it can get into their own property and basically seep into what's called a plume, an underground plume. And oftentimes, what will happen is that plume will then migrate under the surface in our groundwater down gradient to your property. So it could be an industrial user that's a next door neighbor. It could be an industrial user that's several blocks down the road. And you think, how can this happen? We didn't see anything oozing across the grass or on the ground or the pavement. And the way that happens, it actually happens underground oftentimes. There are instances that are more obvious where it's happening in the soil or above the soil, where you can see something that's happening in that fashion. And then really the third way is what's called vapor intrusion. And oftentimes that's related to that groundwater migration. And after it migrates onto your property, there actually could be vapors that are typically odorless, that you can't see or smell, that actually get in through the groundwater up to your house or your commercial property and into actually the home itself. And that can be a really dangerous situation that you're not even aware of.
Yeah, for sure. I grew up in a mill town, and so now as you're speaking, I'm like, I wonder how many families that lived near the mill dealt with stuff like this. I know that it was always very smelly in the town from the chemicals and stuff. A property owner was told the pollution started somewhere else entirely and can't understand how it reached them. What is groundwater contamination and why does it spread so far from the source itself?
Yeah, so if you think about it, when water or chemicals or contaminants, once they get into the soil, they eventually go down. Gravity causes them to go down. And we all have heard about groundwater tables, right? That's actually like these oceans of water that live below us. And when those contaminants get into that groundwater, just like a river, it can go down gradient, meaning downhill. If you think about a river going north to south, these contaminants in groundwater can actually travel in a similar pathway. They usually happen a little bit differently because they're packed with some soil and other types of solids. So it doesn't flow necessarily as quickly as a river does, but it still will over time flow down gradient. So even if let's say that the industrial user is lower than you above the surface, the actual groundwater could be flowing down gradient towards you. That's usually the way we're talking about groundwater migrating from sometimes long distances, sometimes shorter distances onto your property, which can cause your property to be contaminated and your land value to go way down.
Interesting. Now, a family is unsettled to hear that the contamination outside could be getting inside the house that they actually sleep in. What is vapor intrusion and how can contamination get into your home through the soil?
Yeah, and so it's basically that same thing we talked about. When the contaminants migrate under the surface level, it can be sometimes higher up, but usually typically through the groundwater. There are instances where the vapors from those contaminants rise up through the soil because we know how vapors work, how gases work. They rise, right? Gravity doesn't affect them the same way it does water and solids. And so they rise up through the soil, past the groundwater, up into potentially into your house or your commercial property. And it can be really dangerous. And it takes oftentimes very sophisticated experts to do an analysis to understand, is there vapor intrusion? And so if you're worried, if you've been notified perhaps by the Georgia EPD or the EPA that you have a migration issue, it might be worth it to talk to an attorney or talk to an expert who could test your house for that vapor intrusion to see if there's actually, it does pass into that other thing we were talking about, that personal injury claim, which is also a possibility in addition to the land devaluation property claims.
What does that test look like, and what kind of expert would you call upon for something like that?
There are several different types of experts who would test something like that. And they have, I don't know the technical terms for exactly what they're using, but they have sort of sniff tests essentially. So just like what you see, carbon monoxide, something that is a big issue that we know about. So a lot of people have carbon monoxide detectors in their house. There are experts who test for other types of vapors that you don't typically see on the marketplace that you can plug into a wall, that's a little bit more sophisticated, that is able to understand the air quality. What are the constituent parts of that air? Are there vapor intrusion contaminants in that air that we need to be concerned about?
Okay, got it. Now, if a property owner, they keep hearing the word nuisance and assumes it means something minor like a loud party, what is a private nuisance claim, and how does it apply when a neighbor's pollution ruins your land?
Yeah, so nuisance, that definition is probably more misinterpreted than any other type of legal definition that we talk about. All a nuisance means definitionally under Georgia law is something that unreasonably interferes with your right to enjoy your own land, right? And so that could be a number of things. We've talked about migration of contaminants and things like that. A nuisance actually doesn't even necessarily require the contamination to migrate onto your land. A nuisance can actually be brought when something nearby is noxious or creates too much noise or possibly creates a smell. You mentioned the smell earlier. Something that's unreasonable, that shouldn't happen, that causes you to not be able to enjoy or fully enjoy your land like you could beforehand. That's the sole definition of a nuisance. Now, the actual proof of that and the legal parameters that allow you to recover for that and to what extent, that's something that's a lot more nuanced and requires a much further workup of your case. But just very simply, it's an interference of your enjoyment of your land.
Let's talk about someone is confused about why their lawyer mentioned two different claims for what feels like just one problem. How is trespass claim different from a nuisance claim in a contamination case?
That's a great question. Sometimes they end up being the same thing, but sometimes they're very different. Trespass actually does require something to physically be present on your land. So earlier we talked about nuisance doesn't necessarily have to have a contaminant cross boundary lines, property boundary lines. For a trespass to be brought, you actually do have to have that. So again, whether it's through groundwater or through the air or through the soil, whatever it may be, it actually has to pass onto your land to be considered a trespass. Typically, what we see in these migration cases where the contaminants migrate from another property to your property is we're pleading both nuisance and trespass because there are different benefits of both legally, what you're allowed to recover, the standard of proof that you have to bring. But also it's good to just have multiple theories of liability going into a case in case one of them potentially does not pan out. So oftentimes in these land devaluation cases, we are alleging both trespass and nuisance for the same action.
Okay, that totally makes sense. A property owner is frustrated that the company keeps insisting it followed every single rule. When does a polluter face strict liability, no matter how careful they say that they were?
Sure. When you as an industrial type of company are engaged in a what's called an abnormally dangerous activity, it doesn't matter if you followed every regulation, every procedure, there is still some inherent risk to that. And so they can be held strictly liable, meaning even though they didn't act negligently, they can still be held liable for trespass and nuisance. Again, I keep going back to this example, but when we talk about migration of contaminants, typically through groundwater, even if they followed every regulation, it doesn't mean that it still didn't create a large plume of chemicals under their own property. If that plume migrates onto your property, you could still hold them liable for significant damages.
Yeah, lots of things here that you don't think about on a normal day. So I'm
Right.
glad that we're going into all this. A homeowner is worried that the company will blame some other source and just walk away. How do you actually prove the contamination came from that neighbor and not somewhere else?
The defense will always blame someone else. Doesn't matter if there's good evidence, bad evidence, whatever it may be, they're always going to try to shirk their obligation and blame you, perhaps blame a former property owner that used to be on your property. And I'll give you a great example of this. That $7.25 million settlement we had, that was exactly the tactic. Even though this manufacturer had been producing high levels proved by the Georgia EPD and by groundwater testing of benzene and chlorobenzene, these really highly carcinogenic materials. And even though we could prove had migrated onto our client's property, they still said, well, the former property owner that your clients bought the property from had some gas tanks, which gas has benzene and chlorobenzene at times in it as well. They had gas tanks that were buried in the soil. And so it must have been from that. They did everything they could to try to blame someone else and not take responsibility. Unfortunately for them, we had very good experts. We had what's called a hydrogeologist. We'll probably talk about that a little bit later on, who's somebody who can go through and understand the migration patterns and how to refute those defenses. There are chemical markers that you can look at that can tell you, did this chemical come from this production over here, or did it come from the gas tank over here? And so there are ways to overcome those. It takes somebody who understands these cases, who understands sort of the science behind it and the experts that are necessary to prove up the case. But there are very good methods to bat down some of these defenses that we always see manufacturers and property owners have.
A property owner is realizing this is not a case they could ever prove on their own. What kind of expert hydrologist, environmental engineer does this case like this need? I know we've talked about that a little bit, but I would love to go a little bit deeper into this.
So most people have heard of a geologist. It's people who study land and rocks and the way it works. A hydrogeologist is a subspecialty of that, and very specifically is someone who's able to talk about how water interacts with the earth. And more particularly, they're able to talk about groundwater and how groundwater tables migrate down gradient and how they might migrate from one property to another. An environmental engineer is another expert that you can oftentimes use that can chemically ID, like we mentioned earlier, what constituents or markers are in these chemicals that we know are on your land, and how can we prove that came from somewhere else. You also want an engineer involved, or sometimes a good hydro, to help prove up your damages model. Because we don't just stop with, did somebody pollute my land? We have to prove what is the value of that. And oftentimes, even in land that's only worth, let's say, $2 or $3 million at times, the case actually might be worth a lot more than that, because the cost of remediation, if you have a good expert who can show what that is, might be higher than that. Again, that $7.25 million settlement we had, there was some bad evidence that said the value of our client's property was only about $2 or $2.5 million. So you might ask, how did you settle the case for $7.25 million? We had very good experts who were able to reasonably explain why it was going to cost $5.5 million to clean up this property. And so you use these experts to be able to not only prove liability and causation, but what is it worth in this legal context?
So this is the part where the problem turns into a number, what the contamination did to your property's value, and what you can actually recover. A property owner suspects their land is worth less now, but has no idea whether that is something the law recognizes. Does contamination actually lower what your property is worth, and by how much?
It's a great question. And the short answer is yes. Contamination almost always, to some extent, is going to cause some sort of damage, whether that's the property values lower or the cost of remediation are really high. Those are some of the things we talk about. I think if you're really good at working out these cases, you take a multiple approach. You don't just try to prove what is the loss of value. You don't just try to prove how much is it going to cost to clean up. You try to prove all these things at the same time, because they're all things that are real, tangible types of damages. And so the first one you mentioned, diminution in value, that one is in some ways sort of the easiest to prove. It's what was the property worth before the contamination and what's it worth now. Usually you'll use appraisers or other type of environmental experts who can talk about this is what the property might sell for today, and here's the difference between that. That's one form of damages. The other is, again, that damages model on what are the costs of remediation. Scientists have gotten very creative in how to clean up pollution that's 700 feet below the surface of your property. But it's very costly and it takes time.
Mm.
And so you're also entitled to recover for that, the remediation costs. And you're able to, if it causes your property to not be usable during that cost of that time of remediation, you can recover for that too. So if you're a small business and let's say you're making $200,000 a year in your small business, but you can't use your business for 2 years, you can also recover those lost earnings during that time period. The other things we look at are punitive damages. We've talked about punitive damages in other contexts. They're really prevalent here because even though sometimes it might be a strict liability issue, oftentimes these industrial users are skipping steps, cutting corners, doing things that they know are eventually going to cause issues for other property owners. So we talk about punitive damages as a form of damages here. Attorney's fees often are recoverable here, unlike a normal negligence case. So that's why these cases are so overlooked, but they're so valuable, is because there's a ton of different ways to recover. And you don't just have to pursue one, you can pursue all at the same time, typically.
Okay, very interesting to know. Someone has heard the phrase diminution in value and wants to know how anyone actually puts a dollar figure on it. What is diminution in value and how is that number calculated for a contaminated property?
This goes back to probably just the easiest form of damages to prove often. There's some nuance to it, but it's just very simply if the day before the contamination was discovered, my property was worth $10. And after the contamination was discovered, it's now only worth $7. Then the value of the diminution that you'd be able to recover would be the $3 difference, right? And typically, the way you prove that again is through qualified property appraisers, people who can come in and say, people don't want to buy this property anymore because they're worried about the contamination. They're worried about vapor intrusion. They're worried about the EPD coming in and saying, you have to clean this up and it's going to be really expensive. So, what might not even seem like a big issue, pollution 700 feet underground, why does that matter? Oftentimes, that's why it matters. It creates an issue where the property value goes down because people don't want to buy the property anymore.
And nobody wants their property value to go down. I don't plan on moving anytime soon, but I'm definitely concerned about the value of my property staying high. A property owner assumes that once the contamination is cleaned up, their property is worth what it used to be. What are the stigma damages, the value your land loses even after the cleanup is done?
We understand what a stigma is just normally. Maybe in high school, you did something that stuck with you for the rest of your life. You have a stigma against you, even though you might not be that person anymore. You might not do the thing that you did back then that you still have a reputation for, but you have a stigma that follows you for the rest of your life. Property is the same way. Even after it's been cleaned up, communities are small. They understand, hey, that was that property that had all that contamination. And I know they said they cleaned it up, but I don't know that they cleaned it up. How am I, as a normal layperson, supposed to know that it's clean and able for me to buy? So even after it's cleaned up, there can be a diminution in value based on stigma alone, which is just very simply the reputation that that land now has causes that land to be worth less.
And stigma is a big thing. I feel like especially in 2026 where social media and everything is like a big part of people's lives, word passes a lot quicker and stigmas are built a lot easier.
As soon as you go and Google, because everybody does this, when you're going to buy a property, you don't just buy it without any research. You type it into Google or Zillow or whatever it is, it's going to come up and it's going to say that there was this large, maybe you're next to a Superfund site, which we'll talk about that in a little bit. But if you're in one of these zones that has this stigma, and every time someone types something into Google about it, they read about it, they don't have to understand that it's cleaned up. They might never want to buy that property for that reason. Definitely in today's day and age, that stigma follows you a lot further than it maybe used to.
Yeah, for sure. A property owner has been paying out of pocket to deal with the contamination and cannot use part of their land. Can you recover the cost of cleaning up your own property and the loss of being able to use it?
That's one thing, again, we talked about a little bit earlier. And usually that is the overlooked form of damages in these types of cases. It's not just my land is worth less than it used to be. It's that I got this serious issue that needs to be cleaned up. And here's the good thing is we talked about this at the beginning of the episode is that land is unique. All land is unique. And the law actually recognizes that land is unique. And so even though your property might only be devalued by $100,000, that's not a big case, $100,000 case. The law actually contemplates you being able to put your land back in the condition that it was before the exposure to the contaminants. And so that might cost $5 or $10 million. So even though the diminution value isn't very big on a case, you have a right to enjoy your land and have it put back into the shape it was beforehand. And so under Georgia law, the defense should clean it up or they should pay you in a civil suit for the cost of cleaning up that property.
Okay. Now, something else that I mentioned is the loss of being able to use your property. Can we talk a little bit more about that?
Let's talk about the residential context. Maybe there's vapor intrusion, or maybe they have to do some really extensive remediation that causes you to move away from your property. You can recover the cost of renting another house or renting an apartment. You can also recover for sort of the inconvenience of not being home with your things and the things that you're comfortable with. The other form is if you're a small business, right? And you can't operate your business due to a remediation or due to an intrusion or something that causes it to be too dangerous to invite customers onto your property. You can recover the cost of that and the lost profits of that. So again, if you're a small business making $100,000, $200,000 a year, and your property is out of service for 2 years while they clean stuff up, you can recover all of those damages throughout that time period.
That's good to know. Now, a family is worried that living on contaminated land may have exposed them to something harmful. Beyond property value, can you recover for health monitoring if you were exposed as well?
You certainly can. And again, I don't want our listeners to think that I don't handle any of the personal injury side of claims when it comes to toxic torts. I certainly do. I just thought it'd be a good episode to talk about the property value because that's sometimes overlooked. But certainly, if you feel like there's something going on, if you feel like your water's contaminated, or you feel like if you're getting headaches that don't make much sense and nobody can explain it to you, there might be a vapor intrusion issue that you don't even know about that's coming from a source from hundreds of feet under the ground. And so if you live next to some sort of industrial complex, remember, like you said, you smelled things when you woke up in the morning and things like that. Your normal doctor might not be able to diagnose something and you might feel like you're going crazy. But if you trust your body, trust your own intuition, if you feel like something like that's happening and there's some evidence to back it up, call a qualified attorney to talk to you about potentially bringing a personal injury action or some action for medical monitoring. Maybe you haven't experienced the effects yet, but there's still options to have the company pay for you to be medically monitored to see if anything forms down the road.
Absolutely. The last stretch is the practical reality. Who can be held responsible? How the EPA and the Georgia EPD fit in, how long you have under Georgia law, and what to do first. A property owner assumes the only target is whoever owns the polluting site right now. Who can be held responsible? The factory, a former owner, or the company that made the chemical?
This is such a great question. And again, something so often overlooked. I'll go back to the example of the case of the contamination in Glenn County. We sued the current property owner of the industrial site. It's a company called Pineland. But we also sued the former property owner, it was Ashland was the name of the company, and the original polluter, who had, at that point was actually a subsidiary of Ashland, a company called Hercules. You can sue anybody who basically had their fingerprint on the contamination itself. The current property owner, typically the way they're held liable is, let's go back to that plume and that migration of the chemicals onto your property. That doesn't just stop overnight. And oftentimes it doesn't stop over years, decades, sometimes even centuries, right? And so as long as that plume is flowing from the current property owner onto your land, the current property owner can certainly be held liable, but also the historical chemical manufacturer. In our case, Pineland had never actually manufactured the contaminant that we sued them for. It was still migrating from their property, which meant they were liable, but we sued the actual polluter who had stopped producing that back in 1982. Again, we settled this case in 2023, I think. And so it was still flowing at that time from the historical site from 1982 across Highway 17, actually. So you can hold them liable. Sometimes manufacturers of products sell those products to industrial sites. Under certain circumstances, you can hold those manufacturers liable for the pollution as well, depending on the type of chemical and whether they shouldn't have been selling it in the first place. There are options there, but you want to look at all these options and have somebody who understands these cases to be able to unpack who can be held liable.
Got it. A property owner just found out there is a Superfund site near their land and does not know if that is good or bad for them. What is a Superfund or Brownfield site, and what does it mean if your land is near one?
So a super fund might seem like a really fun thing, but it's not super fun to have one of those next to you because that's actually a very bad thing. Essentially, what a super fund is when the chemical pollution on the property next to you or down the street has been designated by the federal government as such an issue that there needs to be national control on the cleanup by the EPA. Usually, Superfund sites are highly toxic, have terrible issues. Oftentimes, the chemicals that are on those sites, because it's such a bad problem, again, there's a plume or some other issue, can migrate onto properties next door or down the street. And so, being next to or near a Superfund site is not a good thing. You also mentioned a brownfield site. That's a next level down. It's a lower designation. That means there's still a chemical contamination issue that needs to be addressed, and there will be oversight. Oftentimes, that's the oversight is on the state level by the Georgia EPD, but also not a great thing. I can tell you in our case in Glenn County, we had both. There was both a Superfund site on one portion of the property and a brownfield site on another portion of the property, both which were contributing contamination onto our client's property.
Does the EPD or the EPA, are they required, or I guess the polluting company, are they required to let the homeowners or businesses in the area know? Or how do you find out that you have a Superfund site or a brownfield site next to you?
Typically, they are not required to inform you if you're near a Superfund site unless there's actually been evidence of a migration onto your property itself. And actually, in our Glenn County case, our clients, even though the company that was polluting their property knew about it years before, they didn't find out until the EPD got wind of the contamination. And actually, it was the EPD that sent our clients the original letter stating, you might have a pollution problem. We need to install groundwater wells to test your property to see if this issue, in fact, is coming onto your land. And so, no, the EPA and EPD at times does not have any requirement and will not notify you if there's a Superfund site or a brownfield site, but they will if they have evidence that it's actually affecting directly. There's actually a national registry. So if you're worried you have a Superfund site next to you, you can go onto the national registry and take a look at all the Superfund sites around the country. It'll probably shock you how many there are.
Yikes. Okay. So property owner assumes that if the government is involved, their problem will get handled without a lawyer. How do the EPA and the Georgia EPD fit in? Do they clean it up, or do you still have to sue?
In theory, you don't have to sue. In theory, the EPA and the EPD will hold the companies to bear to clean up the issue. In practice, that rarely happens. And this isn't a criticism of the EPA or the EPD because they usually have very few resources compared to these large corporations who will litigate the hell out of the cases and throw a bunch of junk science at them to try to get them off the scent. But ultimately, the Georgia EPD and EPA, they're there to monitor and make sure that these companies are doing what's right. But usually the only way to truly hold them to account and to ensure that your property, in addition to their own property, is being cleaned up is to file a lawsuit or to demand payment prior to a lawsuit.
Yeah, and obviously the EPA and the EPD, they can't help you recover stigma damages. That's why it's important to bring in a lawyer because those things are not going to be recovered, obviously, with the EPD or the EPA. A property owner is afraid they may have already waited too long to do anything about the contamination. How long do you have to sue in Georgia, and why can ongoing pollution restart that clock?
Yeah, so typically, so this is the fun thing. Normally in statute of limitations, I feel like I'm the bearer of bad news. The statute says one thing, but sometimes it's actually less than you might think, and you don't have as much time. In these cases, sometimes you actually have more time than it might seem. So typically, you have 4 years in Georgia to bring one of these types of claims against whoever's polluting your property. But oftentimes, if it is a migration situation, an ongoing migration situation, that statute of limitation restarts every single day. So they might
Okay.
claim we polluted your property 10 years ago and you've only got 4 years to sue. Actually, no, you're still polluting my property today. Even though you're not producing the chemical anymore, even though you're not putting it in the ground anymore, the plume that still exists is still flowing from the bad person's property to my property. And so you still have a claim.
Okay, that makes sense. Now, a property owner is convinced something is wrong with their land but has no idea what to do today. If you think your property has been contaminated by a neighbor, what should be your very first step?
This is a common theme in this podcast because the answer is always call an experienced trial lawyer who handles these types of cases. Some trial lawyers in this context will actually charge you an hourly fee. We still do these on contingency fee basis. So free consultations, we're able to take a look at the sort of high level, the surface level, pun intended, facts to see if there's something maybe further there that we want to hire experts and investigate on. But definitely hire somebody who handles these types of cases to help you evaluate these cases and understand, is there something there? You can also contact the Georgia EPD or the federal EPA if you think there's an issue and ask them to investigate it. It might take them a little bit longer and they might not go to the full extent that you want, but it still helps to have their involvement if you can get them motivated to take a look at an issue.
Definitely. With a consultation being free, I feel like it just makes sense to call Conn Law Firm. Before we close, Andy, give the property owner listening right now one piece of advice that they can act on today.
Again, it comes down to intuition. And if you think there's something going on, if you have a sense that your property has an issue, maybe there are things that are unusual that are standing out to you that weren't there before. And maybe you have a new plant down the street that wasn't there before. Maybe that plant's been there for 200 years or 100 years, however many it is, and you feel like there's an issue. Definitely give me a call, have us take a look at whether there's a case there, whether there's something that's happening on your land that should not be happening, and we'd be happy to take a look.
Great. If you believe a neighbor's pollution has contaminated your property or destroyed its value anywhere in Savannah or across Georgia, call Conn Law Firm at 912-373-8642 or visit andyconn.attorney to talk with Andy directly. The consultation is always free. Thanks for listening to Savannah Car and Truck Accident Law with Andy Conn. We will see you on the next episode.
See you later. Thanks, Brooke.